All right, so welcome to everyone who's joining us for this next webinar in our Startup Essentials series. This one is all about co-founders and managing co-founder relationships. So we have with us here from Osler Jacques Duplessis and Ian Morrison, who are going to talk to us about everything you should be considering when it comes to relationships and founding teams. So looking forward to hearing more about that. I just want to let you know if you have questions, you can feel free to pop them in the chat or in the Q&A section on Zoom, and we can look to have them answered as the presentation goes on. And if there's time at the end, then can be a little bit more Q&A at the end of the presentation. So with that, I'm going to hand it over to you, Jacques.
Great, thanks, Michael. Yes, as Michael said, my name is Jacques Duplessis. I'm a partner in Osler's Emerging and High Growth Companies Group, and I'm joined by my colleague Ian Morrison, who also works with me in the same group. And before we're going to get into too much of the content, I just want to give a bit of background of Osler and kind of what we do. So we're a national law firm, a national Canadian law firm. We have offices in Vancouver, Calgary, Toronto, Montreal, and Ottawa, and also a New York office. And so both Ian and I work in, as I mentioned, the Emerging and High Growth Companies Group. So that's our group that works with technology startup companies. And so we work with companies kind of at the early stage as they're incorporating, getting set up, setting up these kind of co-founder relationships and getting things started. And we work with them kind of all throughout as they kind of manage their growth and investment and commercialization and everything up into an exit. So we kind of see everything, and we deal with companies that are small and big companies. And so it's a pretty good experience to deal with these kind of things quite frequently. So we'll get kick things off. And just to kind of set the scene, and we're just wanted to flag kind of more of the well-known founder disputes and founder issues that a lot of people are aware of with Facebook, and a lot of people have probably have seen in the movie The Social Network. And so really what we're trying to avoid here is situations where there's a breakdown of the relationship to the extent we kind of see in the movie. And hopefully what we'll do throughout this presentation is we'll give people a good sense of what are some of the sticking points. How do you help manage that from because our focus is obviously going to be more like the legal structuring side of things, but it's like some of the issues that come up. How do you address it kind of with legal structuring, and what's the best ways to kind of manage that relationship going forward? All right, so um, we just want to kind of at the outset flag how important kind of good co-founder relationships are. About 65% of startups fail because of some form or shape of a conflict between co-founders. It's not always it's not always something that can be resolved. There might just be different views of where the company's going. There might be different views of who's supposed to have what roles and what things individuals are supposed to do. But there are steps I think you can take to ensure that there's right at the outset, to ensure that when you're setting up your company, when you're setting up the expectations of the different co-founders and how the company is going to be run, that'll reduce the chance of there being issues and being a breakdown. And then what we'll talk about a bit as well is, if you do reach that point where there is a breakdown, how do you set up the company, get the right paperwork in place to make sure that breakdown in relation to something that you can manage and doesn't negatively impact the company going forward. And so that the founder that relationship can kind of be separated and kind of move forward. And so really the big theme is, if you want to avoid issues and you want to make sure that everybody's as happy as the right expectations, you want to kind of get things right from the start and kind of have discussions about the company and everything kind of right at the outset. And so the way we see it is, really you want to put in place a legal framework to manage kind of disputes, to manage expectations kind of right from the front. And we'll talk a bit about how you set that up and what agreements you need to enter into. But really you want to start at the beginning, having a discussion among the founders about what role is what people are going to play in the organization. What you set the expectation of who's going to be doing what, who's going to probably take more of a lead role in running the business, who's going to be more on the technical side. And so really, to do that, you need to understand who's bringing what to the company. And it's often these discussions aren't there's there's a tendency to want to just let's just kind of run the business and kind of like we're small, we're scrappy, we gotta just kind of do what needs to be done to get things going. But it's important to think about this kind of at the outset because it'll help set everybody's expectations and reduce friction going forward. And specifically when it comes to legal work, we know that often it's tempting to leave it to kind of later, just feel like just focus on like the business side of things, but it's important to do that. And it's important to do it at the outset because the longer you wait and the more value is built up in the company, the higher the the bigger the consequences are of not having figured these things out at the outset, and it'll cause friction in the company, and it'll have more of a negative consequence as opposed to just kind of putting aside some time and figuring these things out kind of right at the outset. And so really, so what we talked about is like we have to formalize the role that each co-founder is playing in the business, as that comes with day-to-day operations of the business, and kind of just structurally who's in charge for what, who's going to be on the board, who's going to be an officer, and those kind of roles. And so the way we set that up from a legal perspective is there's like a series of documents that you can enter into. And so we have what we call our founder restricted purchase agreement, which we'll talk about in more detail later. Sometimes it's called a reverse vesting agreement, sometimes it's called a founder agreement. There's different forms of these kind of things you'll see, but they all kind of address the same types of issues that you'd want to be able to have a discussion about and figure out. And the other documents, the employment agreement we'll talk about, and just kind of shareholder agreements about like how control is spread across the founders. And really the goal here is to use the discussion and negotiation on these legal agreements to talk about the relationship and roles and responsibilities among the founders. Because if those things are clear, it's going to reduce conflict and misunderstanding going forward. And I often say that a lot of times as like a legal counsel, the actual draft, like putting together the actual agreements and negotiating them are sometimes more helpful than when they're actually in place, because it just gets people to sit down and think about issues and matters that they wouldn't really have thought of or discussed previously. And so that's part of the function of putting in good paperwork and structures to have those discussions and figure out those points. All
So
right, so I'll pass it on to yeah, go ahead. Yeah, go dive right in.
one of those most important early points is the split of the ownership stake between the co-founders. And there's an infinite way to split them. Examples of successful companies in the past have both unequal splits, such as in the case of Microsoft, or equal splits, such as in the case of Google. I think people often default to doing an equal split just because that's simplest, but it should not always just be the default arrangement. The co-founders should really be looking at what each founder is bringing to the table and what role they're assuming in the business. So, for example, someone who's coming on to be functionally the CEO and work on the business full time should potentially have a larger ownership stake than someone who is only doing it part time on the side. And one of the most important ramifications of the equity split is because this equity split is usually set up through voting shares in the company. The equity split has an impact on the balance of the control of the business, such as who can appoint the directors, and also can lead to, by that balance of voting control, can lead to who has leverage should there be some dispute about the company going forward.
Yeah, I guess I'll just add to that. Like, it's how this causes issues in the future is if you're defaulting to, oh, we'll just give everybody like an equal portion of the company and that's going to be fine. But if that equal portion doesn't reflect really what people are putting into the company and the role that they're playing, down the line, it's going to cause friction between the founders. If there's a realization that maybe one person isn't doing as much as the other, and people become acrimonious about the fact just that, oh well, for some reason we have the same split, but I'm doing way more work for the company. So why is it that we have equal shares? So it's good to have that kind of equity split reflect the actual real world, like actual situation of the company. Otherwise, it could just cause animosity going forward and could cause a breakdown of the relationship.
And the equal split can be a straightforward approach, just for obvious reasons. But it can also be an approach people attempt to take to avoid conflict at the outset, or avoid those difficult discussions about whether they are truly putting in sort of equal efforts into the business. But having those discussions at the outset can help avoid more substantial conflicts down the road, when the business is fully fleshed out and has greater value in it. And in circumstances where equal splits make sense, it shows, the equal ownership stake shows a balance of trust and respect among the founders, and shows that they each have an equal stake in the company's success. And it can also avoid any conflict. If they're all pulling equally, then they have ownership stakes, and there shouldn't be a sort of unfair treatment perceived. The challenges of an equal equity split, particularly when, for example, there's two co-founders, is that in circumstances of a dispute, you can just be deadlocked between the two co-founders. And also, if you start out with an equal equity split, but one co-founder is doing basically all the work, that co-founder can feel unfairly treated, and that the other co-founder is getting some degree of a free ride. And so that can disincentivize the co-founder who's doing a lot of the legwork, from continuing to push hard with the business. So it can be tempting to avoid the discussion about how to really balance the equity ownership at the start, but it's an important consideration off the start to ensure that the parties' stakes in the business are properly reflected. An unequal equity split, as mentioned, can be helpful when one founder or one co-founder is contributing more to the company or has already contributed more to the company. So, for example, who had the original business idea? Is one of the founders contributing already completed intellectual property to the business, and what value does that intellectual property have? Will one co-founder be functionally a full-time CEO, and the other co-founder be a part-time founder while maintaining their existing job? An important consideration is did one founder quit a lucrative full-time job with an established company in order to go all in on the company, on this new venture? Those are all important considerations that should be considered at the outset. And then also the degree of expertise and abilities that each co-founder is bringing to the business can be considered. So, as mentioned, is one being the CEO, is one sort of the chief technology officer and has the real expertise for building the business? Is one of the founders the real originator of the idea and is bringing in the others? All these factors can come into play when considering how to set up your equity split among your co-founders. And as touched on, it can be tempting to do an equal split at the outset because it avoids challenging discussions, but that open communication about what each co-founder is expecting and what ownership stake they're expecting based on what they're bringing to the business is extremely important in order to avoid future conflicts down the road. And external investors and venture capitalists who are putting money into the business will want to know that your distribution makes sense and that it was discussed between the founders, because they're going to be wary of any sort of triggers for founder dispute or friction down the road. And finally, you can reallocate ownership stakes later, but it can be challenging and costly to adjust the pieces of the pie later. So the more thought you can put into the equity allocations at the outset, the better, ideally, the relationships and the functioning of the business should be as you move forward.
Great. So next up, we're going to talk about kind of the main documents that governs the founders when they initially become involved with a company, and specifically their equity. And so really, this is the agreement through which there's various forms of this agreement, and we use a certain form which you'll obviously other forms of it going around, but really it covers the basis of the founder purchasing their or getting their equity in the company. And it kind of it establishes what happens to that equity should a founder or leave the company, and it puts also kind of certain restrictive covenants to what happens when a founder leaves the company. And really, it's all a tool to manage. I know it manages co-founder relations with a co-founder conflict, but making it clear and setting expectations of what does a founder need to do in order to earn their equity over time, and what happens when that founder leaves the company. And so we'll kind of go through some of the more mechanics of that process. But this is really the main agreement that deals with the consequences of departing company and the equity. So the way that this is managed is usually companies will put in at the outset, when it comes to founder reverse vesting on the founder's shares. And so what this means is at the incorporation, a founder will be issued their kind of large portion equity stake in the company. The idea is that you're getting this big equity slip, but in order to kind of like, quote unquote, earn that percentage of the company, you have to spend a certain amount of time working for the company. And usually we see that as being like a 3 to 4 year period. And sometimes it'll be like an optional 1 year cliff, meaning that 25% of that, if it's a 4 year period, will vest after 1 year, and none of that vests up until that point. And after that, it'll be a monthly. And so really, how does vesting works is essentially the company would have a right to repurchase your shares should the founder leave the company before putting in their period of time of work with the company. And so they'll be able to do that for nominal consideration. The longer the founder stays with the company, the less amount of shares the company can repurchase when a founder departs. And so really what allows the vesting to continue over time is the founder maintaining their relationship with the company as an employee and an officer. And if for whatever reason they decide they're going to pursue a different occupation, or just going to pursue a different venture, and they leave the company, then this gets triggered and shares can get repurchased. And so really it's a way to make sure that founders are incentivized to contribute equally to the company going forward, and that if someone does leave, they don't end up with a large portion of equity, which they haven't necessarily really earned yet. And so it just kind of helps having this structure in place at the outset, just reduces friction when they're down the road if a founder has to depart the company, and it deals with, and we'll go a little bit more about the mechanics later, but to deal with how the shares get repurchased. And so typically, as I kind of mentioned, a repurchase trigger is really if someone ceases being involved in it. And what we usually tend to keep it pretty broad, because the way the founders engage with the company can change over time. But really, if they cease being involved as the employee, consultant, advisor, officer of the company, then the company has the right to repurchase any of the unvested shares. And really, like as I mentioned, the goal really is here to incentivize employee to remain with the business and reward those who do. And to really as I mentioned, avoid having founders have a large chunk of equity in a company where they've only spent a limited amount of time. And so this really is a tool of realigning equity ownership and incentivization when it comes to how much effort people are putting into how much time they've spent with the company. And so the other kind of tools of how to manage kind of the departure is, usually you'd want to put in some mechanism in place that limits the control that a departing founder is going to have on the company after they leave. So we'll sometimes see a power of attorney gets put in place. We'll often have the voting shares being exchanged for non-voting shares. And so really what that allows is for the founder who's departed, they get the economic benefit of the shares they've earned over the time that they were there, but they don't get to now use their big portion of shares to limit and control the company, because they're no longer involved with the company, so they shouldn't have a big influence on those kind of decisions anymore. And so that's kind of the justification behind that. You also want to make sure that these agreements cover and deal with kind of any kind of director seat that the shareholder might have in the company. Because really being a director in the company, and on offer at the outset, the founders will be the directors of the company. As that's how you control kind of the day-to-day operations, and that they have a lot of legal authority. And so you want to make sure that if they depart, that they have to resign from that seat as well, so they can unduly influence or cause issues for the company going forward. And that's kind of the goals of those kind of structures, is to reduce the amount of control that an exiting founder might have, and to really reduce their interest to an economic interest they can get if the company is sold further down the road. The other provisions is to kind of manage a founder that's departing, is also, we usually include some kind of non-solicitation, non-competition provision. This is in place during the term, but they're a founder as well, is to make sure they're not off doing other things or using company resources for other purposes. And really it's really just a way to make sure that they're not leaving the company and starting a similar business somewhere else. The enforceability in Canadian law of these kind of provisions is limited. The courts are usually pretty favorable to not restricting somebody from being able to earn a living after they've left a certain position. But when you do put in equity in place, usually that increases the enforceability of those kinds of provisions. But oftentimes just having the provisions in place is a good limiting factor to prevent people from competing or soliciting. Just gives you a point of the agreement where they've agreed to that. And so just kind of more reiterate kind of what we talked about here already, is the possibility of founder exits and how to deal with a founder leaving the company should be something you should address and work on kind of at the outset of the setup of the company. It's not necessarily always pleasant to think about how are we going to deal with this. How, like, when you're starting the company, you just put up a lot of energy and everybody's pretty excited about the thing, and you don't really think about, well, what happens when things go wrong. But it's important to get that right at the outset. And as Kevin mentioned, the longer you wait to do these things, the harder it becomes, and the greater the consequences of not having something in place already. Yeah, and I think we've already kind of covered on that, but it's really just establishing that kind of clear framework and expectations of people on what to do and how to manage things.
So the founder restricted share purchase agreement addresses more of the equity ownership side of things, but it's also important for co-founders to enter into employment agreements with their company. And so the employment agreements, as any typical employment agreement, govern each co-founder's role in the day-to-day operations of the business and their compliance with typical business policies. So it helps to, if you have one founder who's going to functionally be the CEO and another who's going to be focused more on the technology side, it's good to crystallize those roles in employment agreements, so it's very clear to each person what responsibilities they will have, what compensation they'll be getting, what benefits they'll be getting, and because informal employment arrangements can create the real risk of conflict down the road. For example, what's the hierarchy between the co-founders? Is one CEO and is one co-founder reporting to another functionally when they're doing day-to-day work on the business? Are there differing expectations about the salary co-founders will be receiving, or their working hours? Or another one would be vacation policies. If a founder left an established business because they wanted more flexibility in their life, so they want to be able to, say, travel the world while working, does that gel with the expectations that the other co-founders have about how much and where will they be working? And so setting out all of these things in the employment agreements can help to ensure that everybody has a comprehensive understanding of their expectations in the day-to-day operations of the business. And we touched on it a bit already, but some of the key terms, compensation, in a startup company, often compensation can be relatively limited. So having compensations, the salary set out on paper can make sure there aren't any sort of surprises or misunderstandings. Benefits such as health plans can be set out, expectations around working hours and vacation, as we discussed. A very important consideration is termination conditions. So how much severance will a co-founder get if terminated by the business? Because once the business is the corporation and there's a separate board of directors, in theory, a co-founder can be terminated as an employee of the business by the board and the company itself. So it is important to actually consider those termination conditions and how much severance those employees would be expecting in those niche circumstances. And like the founder restricted share purchase agreement, a limited degree of non-solicitation and non-competition obligations can be included in employment agreements where legally permissible. And finally, employment agreements also will set out terminology clearly addressing that the company, the business itself, owns intellectual property generated by the co-founders during their work, and that the co-founders are subject to certain confidentiality obligations in their work. So while the founder restricted share purchase agreement governs the ownership side of things, the employment agreements really focus on the day-to-day operations and setting out the key framework so that there aren't disputes down the road should someone deviate from what's expected. The next part.
Yeah. Oh, just a comment on the employment, because like it is often like, you know, it may often sometimes take a while to get them set up just because companies are early and there's not necessarily enough money to kind of pay for salary and stuff. But it's important still to kind of have that kind of framework and that discussion to set expectations and put in something in place that at least for a startup makes it clear what people's roles are going to be in the business, and to help with that discussion going forward, just so everybody is on the same page about expectations and roles and commitment.
The next big piece of the puzzle is corporate governance. So corporate governance is the higher level direction, administration, and control of the corporation. And it relates to the relationships between the executive officers, so the co-founders in their roles as CEO or CTO, the board of directors, which at the outset will likely be the co-founders themselves, but down the road could include investors and independent directors, the shareholders and other stakeholders of the business as well come into the picture. And so in smaller startup companies, private companies, the framework for corporate governance is primarily addressed through shareholders agreements, which we'll touch on briefly next. And so one of the most important features of a shareholders agreement for a startup company is setting out the expectations around the composition of the board of directors. And this is important because the directors are responsible for the overall management of the business. And a well-composed board of directors is crucial to the success of the business, and it can have a very significant impact on the relationships among the co-founders. For example, if the business wants to take a right turn and go down a different path, that may upset one or more of the co-founders and create friction and the potential for departures like we discussed previously. So board composition is typically set out in a shareholders agreement or in the Canadian Venture Capital Association style shareholders agreements, which are the voting agreement, the right of first refusal and wholesale agreement, and the investor rights agreement. The board composition is contained in the voting agreement. And so at the outset, the co-founders are typically the first directors of the corporation. And in that sense, they are the executive directors. They are the officers who are also directors of the company. But board of directors can also, typically further down the road, have non-executive directors, such as independent directors or investor directors. And the benefit of investor directors, but also primarily independent individuals, is that they are better positioned to provide impartial guidance and oversight on the business. And they can also bring an increased variety of expertise to the board. So co-founders, this may be their first business starting up, but a good independent director may be on several boards of startup companies. So they can really lend that higher level guidance and expertise to the operations of the business. And at the outset, you also don't want to get too large of a board of directors because you don't want to sort of stagnate decision making by having to work through too many people. So you want to keep your board of directors relatively nimble at the outset, but still have a good enough range of expertise and personnel to have good decision making. Some broader considerations when selecting how to compose your board. Consider having an odd number of directors. If you have two co-founders and each is a director and they have a disagreement, you might simply just be at an impasse without any means of having a tie break. So having, you know, a third director, be it an independent or an investor, can help to break any sort of deadlocks. The typical composition at the outset is that founders, through their equity ownership, are entitled to nominate themselves as directors for so long as they continue to provide services to the company. So this is a means of, say, if one of the co-founders leaves because they're no longer providing services to the company, they lose the right to nominate themselves to the board of directors. And this is another means of limiting the control that departing founders have over the direction of the business. So you don't have, say, a disgruntled ex-co-founder as one of the directors. Similarly, you can also tie board nomination rights to co-founders' ownership stakes. So everyone, say, over 25% can appoint a director. And as mentioned previously, having independent directors can help to resolve tough decisions, which are deadlocked. Can also provide fresh perspectives that can help the board with effective decision making.
Yeah, and just to kind of tie, so I think really where we see a lot of the issues from like a co-founder relationship perspective is when you have a situation where there's like a two-person board, and then there's a breakdown in the relationship with the co-founders, and the company gets stagnated where they're just deadlocked and they can't operate, and then you have to figure out, like, well, how am I going to deal? Like, how do we manage that situation? And so really what you want to be sure about is there's avenues in the shareholders agreements and your founders agreements that can help you address that kind of situation. And so I think like having, like as Ian mentioned, like making sure you don't have necessarily like a two-person board and making it uneven, whether it's making sure you add like you have the right people on there, maybe adding an independent, thinking about doing that if there's someone who's a good advisor, that all kind of helps reduce the risk if there being a deadlock. Because really when it comes to management of the company, it's the board that makes the decisions. And so you don't want there to be a deadlock at the board level. And you want to make sure that in your agreements, there's provisions that deal with, as Ian mentioned, like how do we deal with a situation where there's disputes among founders, and how do we get them up the board, and how do we just help prevent the company from being a deadlock? Because I've seen tons of situations with companies where they'll have like a two-person board, and they'll get deadlocked if people just agree on the decision making, and they don't really have a path forward because they didn't put the proper documentation agreements in place. So it's important to think about these things and have these discussions at the outset to kind of help manage issues and disputes that could come from a breakdown to co-founder relationship.
And additional means of improving the functioning of the board of directors and avoiding any sort of friction and founder dispute include things like regular evaluations. So that can be each of the other directors of the corporation provides feedback to each co-founder about, you know, how they're performing their role as a director, and this can help to prevent sort of some of the directors having festering feelings about how if one of the co-founders isn't sort of pulling their weight on the board of directors tasks. And another important means is to have, you know, structured meetings and documented formal decision-making processes. So if you want to be having sort of your scheduled board meetings in a proper way and not just be doing them ad hoc. And so that way they're predictable and documented, because one of the major areas we see of dispute between co-founders would be when decisions of the board are not properly documented. So for example, if one of the co-founders is to receive an option grant, but then the board never documents that grant even for years, and then the company goes to an exit down the road, that can have a very material impact on like the proceeds that one co-founder receives and the taxation of those proceeds. So shortfalls in record keeping can not only cause issues say in due diligence when external investors look at your business, but also cause friction and problems for the co-founders, certain and even economic ones. So it's important to maintain good records of your board operations. And then finally, directors should be working on always improving their ability, their skills as directors through continuous education and learning on that front. And so having good board practices, particularly regular meetings and proper documentation, helps the business to run efficiently and effectively, which will in turn lead to better co-founder relationships and help to minimize conflicts within the higher levels of the organization. And so we've spent quite a bit of time on the legal framework and the legal documentation, which is quite important when should a problem arise. But as Jacques mentioned at the outset, perhaps the more important feature of putting these documents in place is that it forces the co-founders to have the discussions and to think about all of these points so that everybody is on the same page. If you just assume that everybody's on the same page about vacation policy, you might be proven wrong down the road. So if you actually put some time into discussing the founder restricted share purchase agreement, the employment agreements, the board composition, if you put time into considering those things at the outset, then it will ensure alignment and harmony between the co-founders going forward. And then just to maintain, co-founder relationships, they're not strictly legal, they are very personal. So co-founders should be, if they're not in the office together all the time, they should really be having dedicated weekly or monthly check-ins where they talk about like the progress of the business, but also just how they're feeling about the progress of the business. They should spend time together outside of work to make sure they remain gelled. And all co-founders really have to focus on trust and open communication to ensure that sort of any sort of issues that are maybe festering can be put out in the open and resolved. And the legal documentation, and more importantly, the discussions that happen when you're working on the legal documentation really should help the co-founders be aligned and uphold the core values and the common objectives of the co-founders and of the business as a whole going forward. So I think ideally your discussions around the paperwork and getting it in place means everybody's happy, and you can avoid talking to Jacques and I when you have a problem.
Great. Yeah, I think that's it for the formal presentation. So happy. I don't know if there's any questions or comments. Feel free to throw them out, and we can go through some of them now.
Okay, great. So yeah, thanks for that. Yeah, a lot to learn and take away. So for those listening, if you do have questions, you could pop them in the chat. I did want to just ask one question. I know here we talked a lot about the proactive steps that co-founders should take. Do you have any kind of guidance or thoughts to those who have already started their company? Maybe put something in place either through a shareholders agreement, or in some cases for some of the early stage startups, maybe more informally, how they can maybe revisit some of the things that they should have discussed earlier or missed. What any best practices in terms of how they can go back and maybe readdress things that they never discussed before they agreed to, let's say, an equal split beforehand.
Yeah, I mean, like it's obviously, usually I think it's always good to reevaluate kind of over the course of time about what you agreed to, and then kind of think about how things might have to change. For example, the relationships as change or the allocations change down the road. But I think usually it's better to have that conversations kind of better, like if you haven't done it yet, but you need to do it now, it's better just to kind of do it at this point in time. And like there's ways you can do it. It's not, oh, I don't think it's necessarily a matter of, oh, I missed the boat and now like things are set up badly. There's always ways if we can do things and structure things in the right way. But the kind of, usually my view is the earlier the better and the easier just to fix. I wouldn't now say we haven't done it and just kind of put it off. It's better just to kind of address that now and work on fixing it. But it's definitely like ways that you can amend your agreements or enter into agreements now at this stage, and have those discussions now about kind of allocation and responsibilities and roles now. It's just good to not to delay that even further and having that conversations now. I mean, a lot of times like there's probably been informal discussions and conversations about these things, and people have a expectation, and it's just usually good to memorialize that in some kind of documentation, at least if you haven't done so already.
Yeah, we wouldn't view it as that ship having sailed. There's always an opportunity to put things in place down the road when you have an opportunity to do so. But the earlier, the better.
Right. And when it comes to reverse vesting, and I think you mentioned 3 or 4 years is typically a timeline that you recommend. I'm thinking of sometimes there are conversations with co-founders where maybe one, let's say, could have a very different view on that, or maybe expects that there should be more kind of guaranteed or given upfront. Is there any guidance you have on that, how to manage those conversations earlier on? Is it more about pointing people to best practices and just essentially getting everyone to come on board, or anything else you want to add on that?
Yeah, I think like it's a matter of just really like we usually encourage people to go with kind of market best practices standards, and that just kind of avoids having extensive negotiations uh and discussions on that point. And also just ensures that people are doing what's market. I mean, it's helpful from in between the founders if you're doing what's kind of market best practice and standards, and also if it kind of setting aside the co-founder aspect, it's good to have that for when you do get external investment. They're going to expect things to be done in kind of a usually like a standard to market way, unless you can justify the reason for doing something differently. And so oftentimes it's good to have that in place so you can kind of move things forward and quickly.
Okay, it's a good point. So I'm not seeing any questions in the chat, but I think what I've said before is, this will be recorded and posted as well. And if anyone viewing this, does have questions, then you can reach out to us at AgeWell, and we'll look to see if we can get you any answers. And obviously, as was indicated, you may be able to reach out as well to Osler, either whether it ends up being Jacques indirectly or not. They're certainly a partner of AgeWell's, and we're working together to see how we can support startups in the age tech space. So I guess with that, I just wanted to thank everyone for joining us, and also thank you, Ian and Jacques, for a great presentation. It's very useful for us, and we'll definitely be leveraging it going forward.
Sounds good. Yeah, thanks for having us.